you want to say, Mr. Krause?
Judge. Judge, I'd like to direct your attention to 90404 sub B. The character of the victim, offered by an accused or by prosecution to rebut the same, or evidence of a character trait of peacefulness of the victim, offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. We are rebutting the evidence and characterization that's been made both in opening statements and in cross-examination that Anthony Huber was attacking and being the aggressor against Kyle Rittenhouse for seemingly no reason. This is what the defense says.
Do you want to respond?
Well, the response is there's been evidence that Mr. Huber, while Mr. Rittenhouse was on the ground, struck him in the head with a skateboard. So I think that goes to, if I can here, I don't know if that rebuts evidence that the victim was the aggressor when it's really just a fact on video that in fact he did strike him in the head with a skateboard prior to being, and then grabbed his weapon prior to being shot. So I guess the court has to make a determination whether or not the evidence that's been put into the record up to this point would support the idea that we're just saying watch the video, which clearly shows what Mr. Huber had done to, I think it goes, Mr. Rosenbaum was, I think the question is, we've alleged that he's the aggressor here. Mr. Huber, his acts speak for themselves in terms of what he did.
So you're going to that Anthony Huber was not the aggressor?
I'm saying that the evidence shows that Anthony Huber swung a skateboard at the defendant's head. Then he hit him in the back of the head with a skateboard while he was lying on the ground. Then he grabbed his firearm. That's what I'm alleging.
I guess what I'm struggling with. Oh, did you want to say something?
Yes, that's precisely what we have this.
I'm sorry, I didn't hear you.
This is precisely why this rule is here. They are alleging that Anthony Huber attempted to strike Kyle Rittenhouse with a skateboard, missed, and then came and we would say did not strike him with the skateboard, perhaps attempted to strike, but came at him with the skateboard and grabbed the weapon. They are calling him the first aggressor, although now they're apparently not. So we can rebut that evidence, and our theory, as we've laid out, is that these people were going to stop an active shooter, that they were provoked by Kyle Rittenhouse, by his actions with Mr. Rosenbaum, that his actions there were of such provocation as they believed he was an active shooter, he was a danger to all of them. The state, frankly, believes that Mr. Huber is a hero, and that we can present evidence of conduct to rebut this claim that he is aggressively pursuing Kyle Rittenhouse with no basis, which is exactly what they're saying. Mr. Trofsky just laid out the evidence that they have called Mr. Huber the first aggressor against Mr. Rittenhouse. Okay. We can rebut that.
Okay. With respect to Mr. Rosenbaum, the defense has definitely suggested and presented evidence that Mr. Rosenbaum was a turbulent personality and was acting in an aggressive manner, and that is certainly a pertinent trait of character in terms of the question as to who was the first aggressor in the incident between them. I didn't hear a similar attack on Mr. Huber, as I think Mr. Sharafi has just stated. What the defense has offered with respect to Mr. Sharafi is direct evidence that Mr. Huber did actions that the jury actually has the unique benefit in this case that we wouldn't see in 1 in 100 cases, or even that, where they can actually see the action So the evidence that you're offering now is character type evidence, which is really not directly rebutting the physical acts which the jury has been able to observe, as opposed to the case of the Rosenbaum evidence, where they've not seen the act and there was evidence introduced as to turbulent character. So it's rebuttive. Is that a word, rebuttive?
I don't believe so.
Well, let's call it rebuttalistic. As to the...
I think that's twice now a word.
but you know what I'm going to do? I'm going to think about it during the break and read what Judge Weinstein and other commentators have to say, and then it's an interesting point. But my initial suspicion is that this doesn't rebut with the acts which the jury is able to see, because and the statute makes reference to and offered by the prosecution. Where is it here? Offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor.
That's precisely what they presented. If they want to stipulate that Mr. Huber was not the first aggressor in terms of his interaction with Mr. Rittenhouse, I think we'll gladly accept that stipulation.
What did they show? What has the defense offered?
In the opening,
in argument or in either an argument here during the case or an opening or in the evidence, what did they offer on the subject of aggression by Mr. Huber other than the act with respect to the skateboard and any effort he may have made to de-weaponize the accused?
In terms, all we know, and I can be corrected if I'm wrong, the only interaction that I'm aware of between Mr. Huber and Mr. Rittenhouse that night, there may be some pictures where they're sort of seen in close proximity, but the only interaction that I'm aware of between the two is you see Mr. Huber, I believe this was an opening, sort of focuses attention on Mr. Rittenhouse, begin running that way. He either swings and loses his grip on the skateboard or throws the skateboard at Mr. Rittenhouse. It goes to the other side of the road. He then goes and retrieves the skateboard and then goes back towards Mr. Rittenhouse. So I don't see how that is not the defense calling him the first aggressor. It doesn't have to go back all through the night like they've been allowed to do with Mr. Rosenbaum. They are saying, unless they are agreeing that Mr. Rittenhouse was the first aggressor, they are saying he was the first aggressor by throwing a skateboard at him and trying to hit him with a skateboard.
Okay.
So we can rebut that. According to the statute. It's plain language in the statute.
Well, I'm gonna see what the commentaries say. We'll take a look. Why don't you come back about 12:25 if you can? Oh, all right, 12:30. 12:30. Aren't you a light eater like me?
Judge, do you mind if I take this out of your courtroom?
You may take it, yeah, as long as you promise to return it.
Well, of course.
We're gonna 12:30.
That's real time.
Yeah, you got it. So you got about 33. Isn't it? All right.